Now, what's in a name? Well, plenty if it's for a business, and certainly enough for two entrepreneurial Melbourne mothers to wage a battle over naming rights.
I don't know how she can sleep at night. I certainly can't sleep at night dealing with all this stuff. It is trademarked and I have an actual certificate.
On the one side, there's Rondalyn Karolak, an author, financial planner, entrepreneur and mother.
A pup and a kitten. They looked like good fun.
On the other, there's, well, let's leave that to her.
My name's Canna Campbell. I'm an author, financial planner, entrepreneur, a mother.
These two clearly have a bit in common, but disagree on one thing, the term financial foreplay, and who has the right to use it.
Financial foreplay is a philosophy. It's about how do we use storytelling and pictures and things that are brain-friendly to make really complicated topics like financials easy for people to get and to implement.
Rondalyn has been using the name since publishing this eye-catching book 12 years ago.
I get all these tradesmen saying, my wife was wondering what this book is doing on my bedside table, and people would joke about it. But if I found that if I could make people smile, if I could get their attention and grab it and hold it, then I could kind of slip the learnings in.
But Rondalyn's smile was turned upside down after Canna Campbell launched a familiar-sounding podcast under her online alias, Sugar Mama.
Welcome back to Sugar Mama's Financial Foreplay. I am financial planner Canna Campbell.
Financial Foreplay is now headed to court.
I've already filed in the Federal Circuit Court because I want a public apology and an acknowledgement that my trademark has been used without my permission.
In paperwork filed for the case, Rondalyn notes her book Financial Foreplay was published in 2009, with a financialforeplaybook.com website launched around the same time. By May 2012, Rondalyn had Financial Foreplay accounts on Twitter, YouTube and Instagram, and by 2017, she'd officially trademarked the term Financial Foreplay with Intellectual Property Australia. Canna Campbell's first episode of Sugar Mama's Financial Foreplay podcast went live in June 2020.
To me, this is a matter of integrity. I want it to stop immediately. It still hasn't stopped. There are still over 500 instances that I could find online where my trademark is still being used.
In December last year, Campbell's lawyer wrote that Rondalyn's action had caused Campbell loss and damage and that Rondalyn was being defamatory, and that if Rondalyn went to court, they would cross-apply to have her trademark cancelled. Later that month, Team Campbell would claim that financial foreplay has entered the public sphere as a commonly descriptive word, citing its use in a Huffington Post article from 2010. But by April this year, Campbell's lawyers wrote that Campbell had now taken further steps to sever connection between financial foreplay and her online and offline presence.
I believe that I have the right to stand up and say, hey, hold on a second. It's my brand.
In a recent Instagram post, Campbell announced that though financial foreplay was, quote, a name I created myself, she was dropping the term, telling followers she, quote, didn't want to misuse or degrade the word, especially for women. Campbell wrote, foreplay is one-dimensional, and the podcast would now be known as Fireplay. What Campbell neglected to mention was that foreplay is currently the subject of a federal court action, in which she is the respondent.
Timing is everything when it comes to trademark ownership. In Australia, the first to use a brand is the first to own it.
Sharon Giovanni is a copyright lawyer.
You basically need to show them that consumers will be confused or caused to wonder whether both goods come from the same source.
As Sharon explains, two brands can exist with the same name, but not in the same area.
So Sharon, what we've got here is two brands called Boost, but in quite different types of products. Does that mean it's okay?
It is okay because you won't have consumer confusion.
So in the case of two products with the same name, both in the area of financial planning, is that likely to be a problem?
I think it is.
Although in Rondalyn's case, ultimately the courts will decide the result and whether compensation might apply, which can happen if someone is found to have made money using another's trademark.
One is called an account of profits, where you basically get the profits that the other person has derived from using your name. and the other one is actually called damages. And damages is not based on profits, but it's a more loose figure that the courts can arrive at or the parties can agree to.
And is there a cap to damages?
No, there is no cap to damages, no.
Canna Campbell declined a request to speak with us, telling A Current Affair,
"Thank you for your invitation to be interviewed about this matter. Unfortunately, I cannot comment on live proceedings before the court. To do so may prejudice the proceedings."
but with a court date looming, Rondalyn still wants to know just how sweet business was for Sugar Mama's Financial Foreplay podcast.
I'm suspecting hundreds of thousands.
Yeah, last week, Canna Campbell asked for proceedings to be delayed, her lawyers telling the court she had recently given birth.